The handcuffs clicked shut around my wrists at 7:43 in the morning, right there at my own front gate, while Barbara Hinton stood 15 feet away with her arms crossed, and a smile I will never forget. She had a signed warrant in her hand. She had 2 sheriff's deputies flanking her. And she had absolutely no idea that the judge who signed that warrant had been calling me Dad for 37 years. I didn't say a word. I just looked at her once, memorized that smile, and let Deputy Morris guide me into the back of the patrol car. The metal was cold through my shirt. The vinyl seat smelled like disinfectant and old fear. Barbara leaned down to the window and said, "Maybe now you'll learn to follow the rules, Mr. Garrett." I nodded. I said, "Yes, ma'am." Then I watched her walk back to her white Lexus, satisfied and victorious, completely unaware that she had just made the single worst tactical error of her entire tenure as president of Riverbend Estates HOA. Let me take you back 3 months. That's when this started. That's when Barbara Hinton discovered that my property line extended 4 feet farther north than she believed it did. Riverbend Estates sits on 240 acres of what used to be tobacco farmland in Carteret County, North Carolina. The development went in during 2006. I bought my lot in 2009, 2 acres at the northwestern edge where the HOA's manicured sidewalks give way to actual trees. The property came with an easement for a private gravel drive that connected my gate to County Road 12, running along with the survey plat called the northern boundary of Lot 47. That gravel drive sat entirely on my land, not HOA common area, mine. The 2009 survey was clear. I had it in a fireproof file box in my office, signed by a licensed surveyor, recorded with the county, and referenced in my closing documents. Barbara Hinton did not know this. What Barbara knew was that the gravel drive looked like it might be part of the community pathway system, and in March, she decided it needed to be paved. I was replacing a fence post on the eastern edge of my property when I heard the trucks. 2 of them, diesel engines, moving slow. I walked around the side of the house and found a full paving crew setting up at the head of my driveway. Orange cones, a roller, a truck with a heated asphalt hopper already steaming in the cool spring air. Barbara was standing beside her Lexus in a cream-colored blazer, consulting a tablet. I approached her the way you approach anything that might startle. Slow, visible, no sudden moves. "Morning, Mrs. Hinton," I said. "Can I ask what's happening here?" She looked up with the expression of someone interrupted during important work. "We're paving the northern access path," she said. "It's been on the HOA capital improvement schedule since January. Didn't you get the newsletter?" "This isn't an access path," I said. "This is my driveway. It's on my property." She smiled. It was patient, condescending, the smile of someone who has had this conversation before with people who don't understand how things work. "Mr. Garrett, the community pathways are maintained by the HOA under Article 9 of the governing documents. This area," she gestured at my gravel drive, "falls under that provision." I told her, politely, that it did not. I told her I had the survey plat and would be happy to provide a copy. I told her the paving crew needed to leave. She said the work was proceeding as scheduled. Then she turned back to her tablet. I went inside, pulled the survey plat from the file box, made 2 copies at my home printer, and brought them back outside. I handed one to Barbara and one to the crew foreman, a man in a yellow vest who looked at it, looked at the property line marked in red, and then looked at Barbara. "Ma'am," he said carefully, "if this is accurate, we're setting up on private land." Barbara didn't even glance at the document. "That survey is outdated," she said. "The HOA had the boundaries redrawn in 2018. This area is common property now." The foreman said he'd need to see that updated survey. Before proceeding, Barbara said she'd have it sent over by end of business. She told him to start prepping the surface. I said, "If you lay 1 shovel of asphalt on this driveway, I will have it removed at HOA expense and file for damages." Barbara looked at me for a long moment. Then she said, "Mr. Garrett, I don't think you understand your position here." I said, "I understand it perfectly." The crew left. Barbara stayed in her Lexus for 10 minutes, typing on her phone, before driving away. That evening, I received an HOA violation notice citing obstruction of community improvement projects and failure to cooperate with board directives. Fine of $500. Due in 14 days. I called my daughter that night. Sarah Garrett had been appointed to the district court bench 8 months earlier, the youngest judge in Carteret County in 2 decades. She'd spent 12 years as a prosecutor, for more in private practice, and had a reputation for preparation that bordered on obsessive. When I told her about the paving crew and Barbara's claim, she listened without interrupting, the way she always did when something mattered. "Do you have the original plat?" she asked. "Filed and recorded. 2009. And she's claiming a 2018 resurvey that reassigned her property to common area?" That's what she said. "I've asked for a copy 3 times. Nothing." Sarah was quiet for a moment. Then she said, "Dad, that doesn't exist. Boundary changes require owner consent and county approval. If she'd filed something like that, it would be in the public record. I can pull it tomorrow. I'd appreciate that. And Dad," her voice shifted slightly, "don't escalate. Document everything, stay polite, and let her keep talking. People like this always overreach." I told her I would. The next violation notice arrived 6 days later. This one cited unauthorized gate installation. The gate in question was the same iron gate I'd installed in 2010, the one that had been photographed, inspected, and approved by the HOA board under the previous president. But Barbara's notice claimed it obstructed emergency access to common areas. I responded in writing, attached photos of the original approval letter, and requested a formal hearing before the board. Barbara denied the hearing request. She said the matter didn't warrant full board review. The fine increased to $1,200. Sarah pulled the county records that week. There was number 2018 resurvey. There was no boundary modification. There was nothing in the file except my original plat, clean and undisputed. I sent Barbara a certified letter with a copy of the county records search and a formal demand to retract both violations. I gave her 10 business days. She responded by putting a lien on my property. The lien notice came via the county clerk's office, filed by Riverbend Estates HOA for unpaid assessments and fines totaling $1,700. It was legal procedure, technically. HOAs in North Carolina have that authority. But it was also leverage, the kind designed to force compliance from people who can't afford to fight back. I could afford to fight back. I hired Catherine Sobel, a real estate attorney in Morehead City who had handled 3 prior cases against Barbara Hinton's HOA and won all of them. Catherine reviewed the file, the violation notices, the lien, and Barbara's correspondence, and then she said the same thing Sarah had said. "Let her keep going. She's building your case for you." Barbara kept going. She sent a formal trespass warning, delivered by an HOA security contractor, informing me that my use of the northern access path was unauthorized and that continued use would result in legal action. I documented the warning. I photographed the contractor's vehicle, his credentials, and the notice itself. Then I drove my truck down my own driveway, the same way I had every day for 14 years, and parked it in my garage. 2 days later, Barbara filed for a restraining order. The petition went before the magistrate on a Tuesday morning. Barbara appeared with the HOA's attorney, a man named Paul Vickers who had the smooth, practiced demeanor of someone who did this often. They brought printed satellite images, HOA bylaws, and a statement from Barbara describing me as hostile and uncooperative. I brought Catherine and the survey plat. The magistrate reviewed everything, asked 3 questions, and denied the restraining order. She told Barbara that HOA bylaws do not override recorded property boundaries, and that if Mrs. Hinton wished to dispute the plat, she needed to file a civil suit, not a restraining order. Barbara went quiet. Vickers whispered something to her. Then they left. I thought that was the end of it. I was wrong. What Barbara did next was breathtaking in its miscalculation. She went to a magistrate in the neighboring district, one who didn't know the case history, presented an edited version of events, and obtained a criminal warrant for second-degree trespass. The warrant was signed by Magistrate Caldwell on a Friday afternoon. By Monday morning, it had been routed through the system and assigned to a judge for arraignment scheduling. That judge was my daughter. Sarah called me at 6 a.m. on Monday. Her voice was careful, controlled. "Dad, a warrant just came across my desk. Barbara Hinton is charging you with trespassing on your own property." I was silent for a moment. Then I said, "That's remarkable. It gets better. The affidavit claims you were warned multiple times and ignored lawful directives from HOA authority. Do I need to come in? They'll serve it today. Let them. Don't resist. I'll handle arraignment. But I'm recusing myself from the trial. This goes to Judge Perro. He's fair, and he's going to be very interested in how this warrant was obtained. At 7:43 a.m., Deputy Morris and Deputy Chun pulled up to my gate. Barbara was with them. She had the warrant in hand, and she was smiling. The arraignment took 11 minutes. I stood before Judge Sarah Garrett in a courtroom that smelled like floor wax and recycled air, while Barbara Hinton sat in the gallery with Paul Vickers, watching my daughter read the warrant application with the slow, careful attention she gave to every document that crossed her bench. Sarah didn't look at me. She looked at Barbara. "Mrs. Hinton," Sarah said, "did you swear out this affidavit personally?" Barbara stood. "Yes, Your Honor." "And you stated under oath that Mr. Garrett was trespassing on HOA common property after receiving lawful warning?" "That's correct." Sarah picked up a second document, the one Catherine had filed that morning. "This is the recorded survey plat for Lot 47, dated 2009, showing the northern boundary and the access drive in question. It's a public record. Were you aware of this document when you filed your affidavit?" Barbara hesitated. Vickers rose. "Your Honor, the HOA disputes the accuracy. I'm asking Mrs. Hinton." Barbara straightened. "I was aware of a prior survey, yes. But the HOA conducted a new assessment in 2018 that determined, do you have that assessment?" Silence. "Mrs. Hinton, do you have a recorded, county-certified document showing a boundary change?" "It was an internal review. That's a no." Sarah set the warrant down. "You obtained a criminal warrant against a property owner for using his own driveway, based on an HOA assessment that doesn't exist and a boundary claim you cannot substantiate. Is that accurate?" Barbara's face had gone pale. "Your Honor, I acted in good faith based on, you swore a false affidavit to a magistrate." Sarah's voice didn't rise. It didn't need to. "I'm dismissing this warrant with prejudice. The matter is referred to Judge Perot for a hearing on malicious prosecution. Mr. Garrett, you're free to go." I nodded. I walked out of the courtroom without looking back. The civil suit took 4 months. Judge Perot presided. Catherine presented the plat, the county records, the violation notices, the lien, the fraudulent 2018 resurvey claim, and the warrant application Barbara had sworn to under oath. Barbara's defense was that she had relied on advice from the HOA's previous management company. That company, when subpoenaed, provided emails showing Barbara had never consulted them about the boundary and had in fact been advised twice not to pursue the paving project. The judgment came in October. The lien was vacated. The fines were voided. The HOA was ordered to pay $14,300 in legal fees and court costs. Barbara Hinton was removed from the board by a 6-1 vote 3 days later. The paving crew never came back. On a cool morning in November, I stood at my gate with a cup of coffee and looked at the gravel drive, the same drive I'd used for 14 years, unchanged and unobstructed. My daughter's car pulled up just after 8. She stepped out in jeans and a sweater, off-duty, and walked over. "You didn't have to recuse yourself," I said. "Yes, I did. It was the right call." "She had no idea who you were." "No." Sarah smiled faintly. She didn't do her homework. We stood there for a while, not saying much, just two people who understood that the law is not a suggestion and that the person who knows what they own, and who's willing to defend it properly, will always outlast the person performing authority they don't actually have. Barbara Hinton moved out of Riverbend Estates 4 months later. The new HOA president sent a formal apology letter and a request to meet about community relations. I declined the meeting. I kept the letter. My gate still stands. My driveway is still gravel. And every time I pull through it, I think about that morning, the handcuffs, the smile, and the warrant signed by a judge who had every right to be furious but chose instead to be precise. Sometimes the quiet wins are the ones that last.